The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcasting Management, or its sponsors.
In 1887, the first law establishing the C.P.A. designation was enacted. Hi, I'm Scott Cheslowitz, C.P.A. and partner of the firm Rothenberg Peters. For decades, our firm has represented individuals, corporations, partnerships, as well as estates and trusts successfully through the maze of the ever-changing tax laws. Please contact us at rothenbergpeters.com. That's rothenbergpeters.com, or call 516-773-3200. The tax return should be the culmination of proper tax planning from the previous year. In 1887, I do not think CPAs could have predicted the complexity of tax laws today. Tax planning is the first step to a well-prepared tax scenario. Please feel free to contact us for a comprehensive tax review. Visit rothenbergpeters.com. That's rothenbergpeters.com, or call 516-773-3200 for an immediate appointment. Hello, everybody. This is Scott Cheslowitz with another exciting section of Tax Talk. You know, when I come to you every week, the show is called Tax Talk, but I like to not just speak taxes, because what I do as a CPA professional within my firm, Rothenberg Peters PLLC, is I'm involved in every aspect of the client's financial life, whether they're a business or an individual, as I've explained in prior shows. You can reach me at rothenbergpeters.com. That's rothenbergpeters.com. 516-773-3200. And today I have a wonderful bankruptcy attorney, Adrienne Woods. Now, Adrienne, you heard how I told people how they can reach me. Tell them how they can reach you and a little bit about yourself.
Thank you for having me on. So my name is Adrienne Woods. I've been practicing in the field of bankruptcy law for more than 15 years. And you can reach me at 917-447-4321. Again, that's 917-447-4321. And you can also see my website at woodslawpc.com.
That's great, Adrienne. You know, let's get right to it. Of course, there isn't going to be, the time to cover everything. We'll go over the basics with reference to bankruptcy law. But how does a person know whether they should file themselves individually or for their business for bankruptcy?
So, Scott, that's a good question. Generally speaking, if you're having a difficult time paying your bills, it's a good idea to at least start a conversation with a bankruptcy attorney. And most bankruptcy attorneys will give you an initial consultation at no cost. This is a great opportunity to see if you qualify for bankruptcy, and if so, whether it will be helpful for you. Whether you personally or your business are experiencing financial distress, however, it's important to have that conversation as early as possible. Speaking with an experienced bankruptcy attorney early on can help you avoid making mistakes that could hinder your ability to file an effective bankruptcy. And if you aren't sure that you're ready to speak with a bankruptcy attorney yet, I encourage people to speak with, frankly, people like you, Scott, that are accountants and trusted advisors, for an honest assessment of the sustainability of either their business or their individual rate of spending.
Yeah, that's absolutely correct. I pry into my clients' lives, and I like to be proactive, and that's what, the basis of having you on for this show today is, because I'm concerned at this date and time for a lot of businesses and a lot of individuals that are out there, but we'll get into that a little more after. So just for our listeners, Adrienne, what do you mean by effective bankruptcy?
Well, when I refer to an effective bankruptcy, what I mean is a bankruptcy where the debtor has the best possible outcome, where they're really set up for success. So this is accomplished by avoiding mistakes before filing for bankruptcy that could result in objections to your discharge by creditors or by the Office of the United States Trustee.
Yeah. So that's right. So, ultimately, You want an effective bankruptcy, everybody. And you know what? Following the rules of the law is germane to carrying that out. So what kind of mistakes can hinder the ability of a person or business to file an effective bankruptcy, Adrienne?
Well, there are a lot of them, unfortunately, a lot more than we could cover here today. But there are some basic things that any experienced bankruptcy attorney will tell you not to do. For instance, you can't take out cash advances within the 70 days before you file for bankruptcy. You shouldn't buy luxury goods if you think you're going to file for bankruptcy, but certainly not at least 90 days before filing for bankruptcy. If you have a business that you plan to file for bankruptcy, you should be certain that you're keeping your business and your personal finances separate. This is a big issue, I find, for a lot of small businesses. They don't maintain the corporate formalities, and this results in problems. And then the other thing is there are things you should do. For instance, if you have cash and you haven't contributed the full amount to your IRA, you should do that. Retirement income is exempt, and not taking advantage of this deprives you of thousands of dollars in exempt assets.
Yeah, that's an excellent point. So does this prevent somebody from setting up a business retirement plan, Adrienne?
Well, if you set it up prior to filing for the bankruptcy, and you're following the rules on how much you're allowed to contribute, that shouldn't be an issue. But I advise people to really talk to someone before they do anything if they think a bankruptcy is on the horizon.
Yeah. So I know there's probably no bright line test. So, for example, if somebody talks to you and then they say, gee, before I officially file for bankruptcy, and I'm just throwing out a hypothetical there, 2 days from now, in 1 day, I'm going to set up a plan and fund it. What do you think about that?
It probably isn't the best idea in the world. I mean, ideally, these financial decisions are made far in advance, which is another reason why it's a good idea to have the conversation with your trusted professionals early on.
You should always be open with your accountant, because only at that point, can your accountant steer you in a direction to possibly help you or send you to other knowledgeable professionals like Adrienne. So, Adrienne, if you file for bankruptcy, are all your debts discharged?
So for individuals, this depends on the kind of debts you have and under what chapter of the bankruptcy code you file, as well as other factors. So many common debts, like credit card debts, medical bills, they'll be discharged. Tax debts may be dischargeable depending on the kind of tax debt and how old it is. Mm-hmm. Private student loan debts are currently dischargeable in the Second Circuit, and federal loans may be discharged in some situations.
Right. Now, let me discuss a few of the types of tax debts that may not be discharged. And Adrienne, you're welcome to chime in at any time. But trust fund liabilities, for example, that may not be discharged. And what is a trust fund liability? Trust fund liability is where the employer has any kind of withholding taxes, for example. So you're talking about federal withholding taxes. You're talking about Social Security and Medicare taxes withheld from the employee's paycheck, state taxes, local taxes. You are essentially a conduit as an employer, collecting the money from the individual employees and sending it to the government. That's not your money, and that should not be discharged in bankruptcy. You agree with that, Adrienne?
Absolutely. It's a very important distinction, which is yet another reason why you should talk to a trusted professional if you're having issues. I recently had someone come to me who had a significant amount of tax debt. Unfortunately, it was withholding debt from employees' paychecks. Mm-hmm. And the problem is not only does that stay with the business as not being dischargeable, but it's imputed to the individual who manages and runs the business. So now this unfortunate gentleman has a large tax bill that he personally owes, and there's nothing I can do for him at this point.
Yeah, I mean, any responsible party, and that could even be a bookkeeper of a business, somebody who's paying the bills, who is steering the direction of the cash flow, for example, could be deemed responsible parties. So, you need to speak openly and candidly, with your professionals. Now, there's other ways besides bankruptcy to make those go away painlessly. Maybe not by any sort of forgiveness or discharge. It depends on the circumstances, but you can set up installment plans. And the thing about trust fund liabilities, they do go down to the responsible parties. So this is my first segment today. Scott Cheslowitz, RothenbergPeters.com. That's RothenbergPeters.com. 516-773-3200. Be back for the next segment shortly. Hello, everybody. Scott Cheslowitz back with segment number 2 of Tax Talk. And today I have a wonderful bankruptcy attorney, Adrienne Woods, who's with me. And Adrienne, we're going to continue a little bit about what taxes are not discharged in bankruptcy and what are. Are there a few tips you want to give us?
Yeah, so Scott, basically, there are a few conditions that you have to meet if a tax debt is of the type that is dischargeable. So we were talking before about how trust fund taxes are not dischargeable. But even if it's, say, for instance, an income tax, right, something that could be discharged, you still need to make a few conditions. So the relevant tax return has to have been filed at least 2 years before you file for bankruptcy. There can't have been any indicia of fraud. So, if you did something to intentionally avoid paying the taxes, like changing your name, that's going to be a problem. Similarly, the tax has to be assessed and actually due from a period of time past. So there are a few conditions that you need to meet. So again, you should have a conversation with your accountant and your lawyer if you think you might have tax debt that you can discharge, because you may or may not be able to.
No, absolutely. And to your point, Adrienne, most important, you really can't play games with the law, because that's not going to save you in terms of not paying your taxes. And, there are conditions out there that you need to speak to your accountant and your bankruptcy attorney about before you go about doing this. And the right bankruptcy attorney is going to tell you the truth. They're not just going to tell you what you want to hear and take your money. They're going to say, well, this is a problem or it's not a problem. And you need to have your professionals in the room. I've always said, Adrienne, that people need to buy advisory services. Now, that's taboo, right? When a professional comes out and says, you need to spend money and you need to spend it on me, because it sounds self-serving. Well, you know what? I would never tell anybody to buy advisory services where they're not going to get a substantial benefit.
Absolutely.
Absolutely.
People can be really penny wise and pound foolish, I find, in terms of not wanting to spend the money on professionals. And then, unfortunately, they end up spending more money down the line.
Absolutely, Adrienne. So, you know what? We covered a few topics, but tell me a little bit about businesses and filing for bankruptcy.
Okay, so unlike individuals where you get a discharge in a bankruptcy, businesses don't technically get a discharge, but in Chapter 7, the business ceases to exist, so the net effect is the same. Businesses and wealthy individuals, however, can also file under Chapter 11, which provides an opportunity to restructure debts, eliminate unfavorable contracts and leases, and generally reduce financial pressure to enable the business to continue to operate. As with individuals, perhaps even more so, the key is really to talk to your bankruptcy attorney and your accountant early on, because if you wait until the business is so far gone that it can't afford to be a debtor in Chapter 11, meaning it can't afford the administrative expenses and there's really no money left to negotiate with creditors, the lenders will lose their desire to negotiate, and you'll have little choice but to liquidate. So starting the process early on can save the business, it can save jobs, or it can at least help management decide whether the business is viable as a going concern.
Mm-hmm. I agree. And, you know, since we've opened up and all of a sudden things have taken off somewhat, I tell my clients this. I say, you know, the customer you were dealing with for 30 years or the vendors you were dealing with for 30 years may not be the same anymore post-COVID, and that could cause financial hardship for you. Don't be in denial. Know your customers. Really, please, reevaluate. Reevaluate your vendors and be honest with yourself in terms of your receivables, payables, debts, everything. Speak to your professionals, your accountants, and maybe you do need a bankruptcy attorney. But Adrienne, psychology is everything, I find. And what about the stigma of filing for bankruptcy?
I mean, unfortunately, the stigma is real, but in my opinion, it is patently unreasonable. So, I mean, first, the right to file for bankruptcy was one of the founding principles of our democracy. Our founding fathers determined that there shouldn't be a debtor's prison. They understood that debt would be a necessary element of building our country, and that sometimes bad things happen to good people. In fact, Article 1, Section 8, Clause 4 of the United States Constitution authorizes Congress to enact, quote, uniform laws on the subject of bankruptcies throughout the United States. So it essentially provided that Congress shall enact bankruptcy laws to allow Americans to exercise their bankruptcy rights. So filing for bankruptcy relief is actually your constitutional right.
Absolutely, Adrienne. And you know, pride does not pay the bills. Pride does not put a roof over your head. And you've got to say to yourself that I have to stick my pride in the drawer because I need to take care of my family. And if you're keeping things from your spouse, eventually they're going to find out. I understand you don't want to hurt them. You don't want them to worry. But eventually, troubles will come to the surface. So please, don't worry about your pride. You know, there are so many famous people that have used the bankruptcy laws to turn their lives around. So, Adrienne, you want to name a few?
Most of them are pretty much household names. So we've got Will Smith, Mike Tyson, Meatloaf, Larry King, Marvin Gaye. Here's a throwback. I'm dating myself. Burt Reynolds. They've all filed for bankruptcy for reasons ranging from tax debts to health issues to unpaid spousal support. Clearly, they weren't embarrassed to file for bankruptcy, and you shouldn't be either. And they all bounced back, by the way. I think that's an important thing to remember.
Now, Adrienne, you know, we grow relationships with people in business and in our personal lives who we're dealing with from time to time. We never want to hurt anybody, especially somebody we know a long time, right? And that's tough for business owners and individuals to get past. They want to pay their bills. But at the same time, right, what do you tell those people when they hang their head and they talk to you like about that?
Yeah, I mean, it's a real thing because, I mean, I dealt recently with a family-owned business that went back 3 generations. So you can imagine that the guy who ran the business, you know, he grew up knowing these people. They dealt with the same vendors for a very long time. And he was very concerned about the stigma of bankruptcy, as most people are, because many of these small businesses have long-standing relationships with vendors, service providers. The idea of not paying them is upsetting. It's embarrassing. They maybe have relationships with their community bankers, and they're worried about how they're going to be viewed. So a lot of people will wait too long to file because they hope against all odds that they'll win the proverbial lottery, never have to disclose their financial distress, and life will go on. But unfortunately, this approach often has the reverse effect. Instead of taking actions that could save their business so they can continue to work with these vendors and service providers, they're paralyzed by fear. And this inaction essentially assures that their worst fears will transpire. Vendors, service providers, lenders, they're often willing to work with you on a repayment strategy, even if it involves a haircut, if they believe in the viability of your business. If you have these conversations early, you can sometimes negotiate out of court, and bankruptcy won't be necessary. But it requires an honest and frank discussion about what's going on with your business, finances, and you need to have the conversation early so that you can present a solution and look credible.
Yeah.
If you promise the check is in the mail for weeks and months on end, hoping that eventually you will have the money to pay the bill, then creditors are going to be skeptical of your ability to follow through on your commitments, and then restructuring either in or out of court becomes almost impossible. You have to start the process when you still have their support.
You know, Adrienne, post-COVID, I'm expecting to see an increase in bankruptcy filings, and people should not be ashamed. This is Scott Cheslowitz, RothenbergPeters.com, 516-773-3200. See you all, well, you'll hear me anyway next week. Take care. Thank you, Adrienne.
The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcast